Good evening, ladies and gentlemen, and welcome to the CDR Talk show on alternative dispute resolution. In today's talk show, we discuss a key mode of resolving disputes and a very eminent alternative dispute resolution mechanism, which is called mediation. Did you know mediation is a concept which was discussed and was prevalent even in the Mahabharata times? Quite surprising now. Yes, it is true. It was even during the Pandavas who used this mode for resolving problems and disputes amongst each other. Thereafter, if you remember, we also had this panchayat system, which was the same form of mediation, where we had elders and the local panchayat masters who used to sit down and resolve disputes between villagers and people. Yes, it is the same concept which is now called mediation. And today, our country is now putting down a framework legalizing mediation and putting down the process to be followed by the people using this mechanism. Yes, we are shortly awaiting a law to be framed on mediation. While a law is being framed on mediation, it is still possible that people can use this mechanism in order to resolve their disputes. And in order to discuss this key topic of mediation, we have with us a very eminent panel and a balanced panel who will be discussing what was the process, what is the process, and how we can use this process, and what are the benefits of this process that the people can use. For joining us today, I'll start right from the center first. We have Justice Vineeth Kothari, former Justice Vineeth Kothari, Acting Chief Justice of the Gujarat High Court. We have former Justice Padmanaban from the Madras High Court. We have Sushma who is right now the standing counsel of the Nagpur High Court. And we have Adeesh, Anto, an eminent advocate from the Madras High Court. And ladies and gentlemen, this is me, Vijjay, Metha, the founder of Chennai Dispute Resolution Center. And here we are today in order to discuss the importance of mediation and how this could help each one of us in order to resolve our disputes amicably and more cost effectively. So I'm just going to shoot around a few questions because we all have been hearing this ADR for such a long time. It's become a hot topic today, and some are understanding the meaning of ADR, they just know the full form, but nobody knows what are the modes of ADRs and how is that a supplement to litigation. So we would like to understand first how ADR works. Justice Vineeth Kothari, sir, may we please start with you?
Yeah, thank you, Vijay. Mediation in ADR is nothing new to this country. Even go back to Lord Krishna's time. He tried to mediate between Kauravas and Pandavas. He went to Kauravas to avoid the war and then advised them that, look here, there are other ways of settling the disputes. And thereafter, right to these panchayat systems of villages in the country. And now we have formal laws for mediation. Section 89 of Civil Procedure Code provides 5 modes of ADR in the provision. But the best ADR system in my understanding is mediation. I rank that above the arbitration because it doesn't have any kind of adjudicatory process which has a psychological pressure on the parties, and they would always try to assert their own side or their own versions or statements. Mediation is a process, I believe, where the disputant parties on both sides are on the negotiation table, and with the help of facilitators like trained mediators, they are advised or counseled that what is in their real interest and how they can reach that settlement of the dispute to get a kind of permanent peace of the, what is the result of dispute resolution? Peace, which is sine qua non, essential for any development work which you take. So ADR is essentially a substitute or a parallel, it's like a bypass of your heart. When you go for heart surgery, what do? The blockages are bypassed and you are put another vein to flow of blood like that. So it's a very good system. Unfortunately, what is the present status of the entire thing is that the idea has not really come to a matured level in our country again. India is known to be overburdened with the workload and caseloads in the courts of the right from top to bottom to bottom to top. So if people like this center and all over the country are make a dedicated effort to promote this system, it can offload the burden of the courts to a very large extent. And ADR, which is called alternative dispute resolution, appropriate dispute resolution, etc., whatever name you give, but then it can help this system. It's a very beautiful system, and I, as a votary of, I've been in litigation side for 40 years now, I still think that this is the best possible system to resolve the disputes.
The alternative dispute resolution.
Yes.
Now, the alternative dispute resolution has three modes: arbitration, mediation, conciliation. We all understand arbitration and to a certain extent what mediation is. What is conciliation, but it's
Conciliation is again a little different. It's not a shade different, I would say, from mediation, because in conciliation also there is somebody to help you to conciliate, try to understand your real dispute, the root of it, and how can you avoid that situation and get a solution which serves your real purpose, and then you avoid the length of time, cost, and all that factors which happen on the other side. So it's a shade different. The Arbitration and Conciliation Act 1996, as you know, has a separate chapter for conciliation, separate chapter for arbitration.
Yes, sir.
And mediation is nowhere in that act. It's in section 89. Now we are having a bill in our country which will be, fortunately or very shortly, will be a law, which will provide a statutory framework for all these mediations to be given a shape, as Jawad was earlier saying, and we all perhaps are one on that point, that it will become an executable decree if a mediated settlement is arrived at. The only thing is that since it's a voluntary process, the faith in this ADR system in the litigants in large, in general, is yet to develop fully, which is taking its own time. So it's more a education kind of thing, promotion kind of thing, which institutions like your CDR are doing and should be doing further also. When the people develop a faith and see it as an effective alternative to the litigation system, I think this system will help the disputants in a very wonderful manner, very beautiful manner, and much less cost, much less time. They will be able to get a piece out of their disputes.
Absolutely. So what we understand from you is mediation is a voluntary process, and the mediator assists the parties in order to reach a solution.
Exactly.
But conciliation on the other side, the person mediating would give the options of settlement to the parties.
Yes.
And then they would choose the... Yes.
So that's what I said. There are only shades different. There's
Right.
nothing watertight compartment between
Right.
two.
Right.
And ultimately you reach a settlement there also and in this
And then dispute
also.
resolution also.
So mediator acts as a facilitator, as a trainer, as an educator, whatever you call it. But then ultimately the parties, it's parties' decision. They have to only go to that level by understanding the pros and cons of all the channels which are otherwise open to them.
Right. Now, we understand what now mediation is about now. Now, how about the time and the cost? We all have been seeing disputes running around in the court and hanging for decades and for centuries. But how is mediation going to come to as the aid of the hour in order to utilize less time of the parties? What exactly is the time frame that we call for? Let's hear it from Justice E. Padmanaban sir, who is the most senior member from the Madras High Court.
See, with respect to mediation, of course there is no inbuilt system by which they can be referred for mediation. Parties themselves will choose. Those who are educated, those who are on the litigation side, they will choose. Better you just, so shall be the mediator, I will refer both of you to him. He will mediate.
Right.
Apprise them what is their rights, at times apprise them what is the right or wrong. Legally what you are entitled to, all those things he will apprise. Mediator is also a competent person.
Mediator is also a competent person. But I'm sure, is the question that comes into my mind, is mediation something that if I'm a disputing party, should I start it at first, or if I would go to the court, I can no longer go for mediation? How is that? How does that work?
Either way it is open to.
So I'm open to approach mediation at any point of time.
There are organizations like yours, they will come to you, this is the dispute between us, you have your mediation center, so that you can improve it.
Right, sir.
If I may just add to what Sir has said,
Yes.
it's a very pertinent question. But if you look at the life cycle of a dispute, the moment a litigant has a dispute, the first person he approaches is, even before he goes to court, he approaches a lawyer. So the lawyers are a very integral intermediary in the justice delivery system. So it's very important that the lawyers are first educated to nudge the parties towards mediation.
Yes, of course.
Even in pending litigation also, judges will refer the matter to a particular mediator, A or B, something like that, competent person. Then they will say, go appear before him, try to.
So do we need a lawyer in order to enter into mediation?
Not necessary.
Not necessary.
Not necessary.
So we do not necessarily need a lawyer.
Only lawyer will intimate this is the provision is available to you, you can go for a mediation.
But I can choose a lawyer because I might always be better placed if I'm advised
The lawyer
and
will-
aware of the legal
If I would
provisions.
say not necessary but advisable.
There is a concept of now pre-litigation mediation also.
Pre-litigation, right, sir.
So the moment the two parties, take for example matrimonial dispute, husband and wife fighting, and their fight is very, very important. So there should be somebody
dramatic fights.
in the family or some lawyer or some law-knowing person to tell them that look here, this will not result in anything good for you in the final analysis.
Even
So why don't you go to
non-practitioner also
CDR?
suggest.
There are people who will tell you that you just come cool, sit on the negotiation table. You may fight also, you may burst out also, give your everything, vent out everything. But then that process has to be taken care. And there the role of the advocates or the lawyers or the advisors, consulators, whatever you say, should be to tell them that these are the pros and cons of the fight. These are the probable costs, these are the probable timelines, these are the court system, these are the appellate remedial systems. You can end up finally in Supreme Court when you will be old persons. And you may not get your divorce degree which you want today. So you can keep on fighting for 40 years, what is the use of fighting? So there should be people to tell you that this will be 40 years before you get final thing. So why don't you sit 40 days, probably you can get something. So that advisory role of the advisors is very important.
Yes.
That is where I strongly feel that lawyers, Justice Padmanaban rightly said, that lawyers, advisors of this field have to take up this concept as a wonderful magical thing. And they should, because disputants coming to you will not know. They will say, no, take him to court, drag her, fight it out. You have to tell them, no, it will be 40 years, are you ready? So first thing you tell them, then they will have a second thought. What is the alternative? Sit on the table. So that is the way this idea has to be promoted. Unfortunately, what I have realized over the years as an experience, I have referred many cases to mediation. I was sitting judge also. I have done settlements, taking the parties to my chamber, advising them. Look here, this is the way out. So these things can be, it's all a matter of taking up the idea and how do you sell it.
Yes.
So firms like yours, CDR systems, if they are on the job, dedicate themselves to develop this system, I think next 10 years you will see the Indian legal system in a different color.
Provided the litigant's mind should not be there. That is more important.
Sushma, anything you as a lawyer, how do you, take this concept?
Sir, actually, I agree with you because I have seen that in petty cases, like where even the relief sought for is not much, even then it takes years. Because I was counsel for WCF, Western Coalfields Limited, and I will give an example. In which one Balaji Travels was the company which was blacklisted by WCF. So they filed a writ petition before Nagpur High Court, and then it took almost 1.5 years. But by that time the company was blacklisted. And for what? Because Balaji Travels was supplying vehicles to WCL, and the vehicles was not in good condition. So it was not something which could not be like sitting, what you have written, stop fighting, start talking.
Yeah.
So I really, actually, when I saw what mediation is, you have written very simple words. That please don't fight for petty things. Like you are the service provider, your job was to give vehicles in good condition to WCL, which you have not done. So you have been blacklisted. Just filing writ petition will not help. That is if some good mediation would have been done, and it was what Sir was telling, that the mediator should not give only solution. They should explain that this is your limitation, what you are going to get in the court. This is the limit, and if you want to get better, come to the table, and then only the things.
Our legal system, you see, is marred by two basic blockades: procedures and workload. Both ways our Indian legal system suffers badly because of the mild procedures. CPs is an old law which should be thrown out by now, and a very simpler law can come. Sometimes when I talk to income tax side people, I see also, so I go there often also. I said income tax act should be scrapped, and I can give you an act of 40 sections which will meet all your things. Very good. I can draft the law for you. Our draftsmen have been so bad, I would great respect to them. Every finance bill in every year brings an income tax act you can't read in one go. There are so many provisions, provisos, explanations, and what not. So our legal laws are many, first of all, and they are complex to top it up. So these procedures and the workload, the courts simply do not have time to devote to a particular case the attention which it deserves. For example, matrimonial dispute, I say. Now, no family court has time to take up your case once taken next 6 months. So, only 2 hearings in a year you get, and it requires at least 20 hearings. How many years? 40 years, I say.
40 years.
So, if 40 years you can't even get your first decree, what to talk of further High Court and Supreme Court appeals?
Decades.
So, no couple can, I told in open court many times, if you come for such disputes to courts, justice is a mirage for you. You will never get it. So please go out of this system as early as possible.
As early as possible.
And that is the room for you. So this is a beautiful concept, mediation. And not arbitration also. Why? Because again the adjudication. There people will again assert. The arbitrator, howsoever high he may be, Supreme Court judge, High Court judge like us, they will have to adjudicate finally.
Absolutely.
As a trial judge.
Yes.
But in mediation, parties are just advised, counseled, educated, what is good, what is bad for them. And then they say, no, this seems to be good via media, why not go for it? Yes. And that is where the iron is hot and we strike it.
Well, talking about that, sir, what do you think is the success rate of mediation? Because we've been following the panchayat system for very long. Even before the courts had come up, panchayat system was always there. But today, why it looks like mediation has not been recognized and it is not being used as a very effective tool today to resolve disputes. Why is that today, sir?
Because of the litigant's mind of the litigant.
I will see you in court.
Yeah, that is the dialogue.
The famous dialogue.
I'll see you in the court. Baba, don't go to see, there you will see nothing. Except lawyers and your pockets cut. I'm sorry to use these two.
Well, I think we have to edit
front of the two
we have to
lawyers.
edit that portion of the comment.
Also,
3 lawyers are there.
Also, enforceability is also there, sir. That what mediation, what they are coming to the what should I say to the final solution. What is the enforceability? That is also important. That when the arbitrators, when they pass some record, so that whether that is equal to that what he is referring to, that some bill is pending.
The binding effect of
So
the
that enforceability is also important. Then
Very,
only the
very
things
good.
will come in proper place.
Right.
At times the mediator sits in the chair of the litigants. Those who come forward for litigation, either a family matter or a matrimonial dispute or family dispute, he will have a confidential discussion with the party also, each individual. Then he persuades, this is your problem, you can solve this way, we can do that.
Vijay, there is another important aspect I should tell in this kind of meeting which you are having. 70% of litigation in our country is against the government, by the government or against the government. Now, how to offload that burden? Litigation is good against the government in a way, but my understanding, the mediation can help resolve even the government disputes against the government. Now, for that, the very important aspect which the government, no government I think has that proactive approach which they should have, to allow their responsible officers to go for mediation even in the disputes against the government.
Right.
Now, there are issues like government company blacklisting a person for transportation. It could have been solved in 2 hours.
2 hours.
You substitute the vehicles, you pay some damages for wrong vehicles which you send, some rate deductions. All right, somewhere the conclusion would have come.
But the litigants
And 2
might
hours
not
gone.
allow.
Writ judiciary you go. Single bench decides in 5 years. Division bench decides next 5 years. And finally the court says, no, blacklist was bad, you go back. What's the use?
Lordship is
It is.
right. It again came down to
No, as a judge, I have decided these kind of cases after 10 years. If I say, go back there, consider this case
It
again.
happened.
What is the use of
Today,
it?
litigation has come to such a shame. I mean, it's just
So-
running for years, decades, centuries.
I said procedures and time.
and yet we are saying we do not have a proper result.
properly.
See, with respect to brother, he was referring to the litigation with the government. You see, even among the government departments, each department is fighting with each other.
Yes.
My goodness, that is so
Oh.
unfortunate.
Right.
One department of central government or state government will be fighting with the other corporation or the other
Or
department.
some
also.
PSU also.
Though there is an organization that they should first refer to the committee of secretaries to the government of 3.
ONGC's case, Supreme Court.
Right.
Like that.
Right.
But ultimately nothing happens because all of them are afraid of somebody.
Somebody.
They are not, don't have any decision making power. They can't tell the government that as a MD of a company, I've entered into the settlement, I find it's in the interest of company, put a seal on that.
They
But
don't
some
have-
secretary will call him up, why did you go for this? You will be held responsible, who will pay all this? He will say, why should I burn my fingers? So that approach has to end. Everybody has to first think that what is in the best interest of the litigant or company or corporation or PUs, whatever. That thinking process has to develop, and that has to be developed by people like us who are in this field.
So the answer is now coming out clean, that the reason why mediation has not been the most preferred way of resolution is because the mindset of the people has changed.
Absolutely.
From the panchayat, from the resolving mindset to a litigious mindset.
Before you proceed further, in a panchayat, what happens is our family members are involved. Our villagers, leaders are involved. They know what is actually the dispute between the parties. They were able to persuade the parties. Why don't you settle another 1 acre, you leave it to him, 1 acre you have.
Yeah.
Something like that they persuade.
Yes.
Then he is your brother or he is your cousin, something like that. They highlight the relationship between the parties and try to persuade them for a settlement. That is mediation.
That is mediation.
That was successful those years. Now strangers come in, so many things are,
Yes.
and so there are
Absolutely.
ultimately 40 years of litigation. The advocate or somebody will be a sharer to that property estate.
That's going to happen.
So now we are again going back to moving the mindset of the people from a litigious mindset to a resolving mindset. Well, then this also comes up as to back in those days, as you had just mentioned, sir, that family members, elders, the local panchayat heads, they were all being involved in order to mediate a particular issue at hand. How is it today? Today, because
today everything is a politics.
If some elders in the family will intervene, the younger ones will say, you mind your own business. Don't get involved. So this kind of, you see, unfortunately, the family values also have gone away.
yes,
And that is the main reason of increase of the disputes of this nature, property disputes, partition disputes, matrimonial disputes. 90% of cases of this nature which come to us, we say it is 99% ego, 1% problem.
1% problem.
So it's ego clash basically. And when they go to court, the tempers are very hot and high. On mediation table, if they are properly advised, it is the time which I said 40 hours against 40 years. It's time to cool down the tempers.
Correct.
Tell them that, look here, you are here in a proper manner here, and if you are advised properly, you will see the sense of being on this table.
Right, sir.
That's what the system should do.
So, back in those days, the disputes were also small, the troubles are not long. Today, because of globalization, development and all of that, contracts are huge, the amount of issues that are there are also bigger in number. Back those days, we had elders being involved. Today, how is it? Today nobody has the time to involve themselves in others' disputes. So, today I think there's a need for a professional person who understands the mediation concept. So how does that work, Anto, today? I mean, do we have professional mediators in the city and the country?
Very unfortunately, though we had a great start in the panchayat system, we lost it somewhere down the line. And we had the Englishman giving us his laws and we tried to emulate him. But now, having started off, it's in the very nascent stage, but I'm very hopeful that down the line, just like we have specialist lawyers in arbitration, specialist lawyers in income tax, somewhere down the line, I'm quite hopeful that we'll have specialist lawyers in mediation. And perhaps, I'm even dreaming further, perhaps we should make it mandatory for any dispute before it reaches the court to pass through one level of mediation through certified mediated lawyers.
Well, we will come to that. We will come to that mandatory mediation a little while later when we speak about the bill which is pending in the parliament. But talking about the skill of a mediator.
Well, because, yes, I agree with you. Because we are in the nascent stages now, we will need some time because a large part of the success of the mediation depends on how the mediator drives the entire process. So, apart from being convinced himself of the nobility of the entire endeavor, it is also very, I wouldn't say difficult, it's very important for him to convince the parties to join the thing and that it is beneficial for both parties. At that stage when tempers are high, when egos are high, it's very difficult for parties to see reason and see that they cannot see the situation 20 years ahead. They are saying it only today. Today I will hack you, I want to see blood, I will see blood. It takes a lot of patience, authority and convincing power to tell the parties that 20 years down the line, this will not be the same sentiment or enthusiasm that you have today. It is much better that you settle your dispute and bury the hatchet 1 year down the line and get along with your lives.
Right. That's where I wanted to emphasize the training of mediators, the skills of mediators. We have only as of now informal sessions or seminars or things like that. The Supreme Court MCPC committee as of now only conducts 40 hours training program, which I also took as a sitting judge of Madras. Now, but this training, this education has to be constant endeavor.
Yes.
A continuing legal education system or mediation promotion system should be in the inbuilt. I don't know whether the new bill contains any such provision, but a constant training and promotion of the idea at the hands of the lawyers or skilled developed bars for mediation, as you mentioned, is very, very essential, because unless there are people in all parts of the country to advise like that, you don't have, it's not a TV serial that you watch every day and you become enamored with this.
So any lawyer and every lawyer cannot call himself as an expert mediator or a person with the equipping those skills.
Mind to mediate.
Does not have the mind to mediate. Right. Right.
They are all parties, very good parties, therefore they must remember us throughout their lifetime, therefore let us try to settle it, mediate, settle it.
And there are cases, if the lawyers advise them for mediation and the disputes get settled, both disputants become your fan. They'll say, here is the right man. He advised the right thing at right time. Avoided all these conflicts.
They will invite for their wedding ceremony.
Reputation building.
So now mediation has now become a different profession, an evolving profession, as I understand.
Yes.
But is our judiciary and our education system equipped enough in order to impart that knowledge to people?
There are no want of personalities like that. Anybody could be a mediator. Anybody with a common sense. Anybody with little education. life of 45 years or 50 years time is sufficient to be a mediator.
No, sir, I would say this education has to go down to school level.
Yes, I think by
Right from secondary school education, college education, post-graduation level, law. You have to tell them that, look here, there is a system in place where, unfortunately, if dispute happens, there is absolutely efficient system in place other than courts,
Right.
litigation, available to you.
Available to you.
Pre-litigation, post-litigation, during litigation, whatever. So this education has to go to, if not primary school education, secondary school education,
Right.
and then throughout.
And then throughout. I mean, can I invite any of the panel members to tell us with their experience what is a process of the mediation that a party has to follow? Is there any particular process?
Is nothing in rules as of now.
There's no process.
But that is what I said. If the idea is promoted properly, the disputed party should first not utter that sentence, I'll see you in the court. Let us try to solve a dispute in some center like this or some lawyer's chamber like this. He's a very nice person. Let us go to him. Let us think. Let us discuss what is happening.
So it's a very informal process.
Very informal.
And the process.
Very informal, and it's only the mindset of the party.
that's the only
Right.
And also the professional, the lawyer should also stick to their professional ethics.
Ethics.
Like if the lawyers, if we will promote litigation, we will just, if somebody comes to us, even just I'm taking example of one very small service matter, that okay, look, my pension was fixed a bit more and the government is recovering from me. The sir might be dealing all the cases. Because 90% of cases in service matter will go for recovery, excess recovery. So it's, as a lawyer, it's like how to do the things without
The developed bar of mediation as we are now, depending on the nature of dispute. Suppose a corporate dispute comes involving 1,000 crores. Two companies are fighting. Well, the lawyer should take 10 crores. Why not?
Why not? Yeah.
If a matrimonial disputes come, poor people, 1,000 rupees, even nil fees, okay.
independence of the
It
mediator.
depends, like matrimonial disputes are
Yes.
there. If while sir is saying that like poor people are there, then it's okay to do. But
Sometimes
if
pro
some big
bono
corporate,
also.
yeah, then okay.
But then corporate cases, why not full good handsome fees?
But so is that called that any and all disputes could be mediated, or there are particular disputes which cannot be mediated? How does that work?
Except criminal cases of serious nature like murder, rape, etc.
Rape.
Which the state prosecutes. All civil matters and petty criminal offences can be mediated.
Communicate. So as we understand, we have family issues that could be mediated. There could be matrimonial disputes. There could be property related disputes between family members or between friends or between corporates.
All
Or it could
service
be
matters.
civil disputes,
Which can be
mediated.
service related matters, pension related matters. I suppose everything
Everything.
except those criminal matters regarding check bounce or with respect to
Check bounce cases are good
even
cases
check bounce
and
and mediation. Oh yes, oh yes.
138 and bylaw litigation can be sorted out here.
My apologies.
Because
yes, check
Supreme Court
bounce.
has said they are
Yes.
compoundable, even though they are not in section 320 CRPC, but the Supreme Court said they can be compounded at
They
any
get
stage.
the money in a second
Any stage of
they
litigation.
will withdraw the complaint.
Right. So apart from any theft or any of those
Bodily harm.
There again the approach of
everything.
court. Court should persuade the parties and cons to go for
Very
mediation.
heinous offences like
And many
murder
a
or
times
something
courts
like
are
that.
doing it.
Yes.
Because especially in family matters, I have seen that the
Yeah.
judges are saying you go for mediation. In case it is not working there, come back to us.
Right.
So that is the process which is being followed in all
Which has
the
been
courts.
followed.
In all the
So
courts.
that is being
Judges also
promoted.
Promoted.
And I am really thankful to the judges who are really doing it.
Right.
So because that's the practice which is going on in litigation.
So as we understand from the discussion so far, we I think we understand that mediation is a easier process. It's a less time consuming process. It is a cost effective process, and most of all, it is a stress relieving process at a very quicker timeline. And but the mindset of the people is yet to change in order to accept mediation as an effective means of resolving disputes.
Right.
And I think this kind of talk shows or seminars, if they are spread across the various forums, some part of education I think should go down to the.
Sir, also like we have to set examples. Like if some matrimonial dispute is there, and that has been settled by mediation, then people will see the example. Okay, look, this has happened.
This has happened.
You should also do like this. So we have to set some examples, some precedences.
Yes, so
Then
that's a
what
very
is-
right thought. Now talking about that, I'm just thinking, what is the success rate so far? I'm sure out of 10, if 2 are also being referred to mediation, are the 2 being resolved by mediation?
In the present setup, no. Unfortunately, success rate is 10 to 20%.
There are few cases you get settled like that in mediation. Very few cases.
But very few cases.
Otherwise, they are going back to the court.
Again, it is mainly because of the lack of the trained mediators who can properly guide them through the process.
But so long as the litigant's mind is there in the mind of the litigants who are,
That is what requires it to be cooled down, sir.
you have to cool down, bring it down, all those things. What is that you are going to gain after 40 years as per the
Yeah.
So what needs to be done? So I'm sorry, Anto.
Yeah,
I mean,
I just want to-
go ahead.
That reminds me of one Caribbean judge who
Okay.
follows a very nice procedure. At the outset, it may look rather strange. Once the matter is in court and the pleadings are over, trial is over, he refers the parties to mediation.
Okay.
He says, "You go for mediation and come back to me."
Oh.
In the meanwhile, he drafts
Drafts his
his
judgment.
judgment. He doesn't deliver it, he drafts his judgment. If they come back and they're successful, whatever is the successful mediation is given to them. Now, if they're not successful, he circulates this draft to the parties and sends them back for mediation once again and tells them, "You come back, if it's unsuccessful, the decree will stand. If it's not successful,
I will tear this. That's a great
That's
mindset.
That's a great
social
mindset. That's a
I think
mindset.
that's
So
a
that kind of
very-
increases the
It's
success
just
rate for
taking
this
that much of
mediation.
interest at the final hours.
In our system of litigation or legal system, that is not possible.
Sir, it's only innovative idea which brother has given.
It's an aggressive step taken
Yeah.
in order to push them to go and resolve it amicably.
Yes.
If you settle, I am ready to sacrifice my labor lust.
Yeah, yes.
But then if you don't,
And then it's
appealable decree.
It's exactly, it's an appealable decree. If it's a decree, it's an appealable decree. Otherwise, you're stopping a litigation here.
Beautiful.
But
Yeah.
there the role of mediator comes. What the judge is writing as a decree, the mediator should tell in advance. Look, if we will go to the court, this is going to happen.
This is going to happen.
This is going to happen.
So, huh.
So, but of course, there may be a change
So
in
you have to
leverages.
now decide.
Yes.
So
So,
that
so
is-
in the second round of
Because through mediation, the parties will always arrive at a better settlement.
But
Right.
so the mediator is like an educator also.
Like
He should
magician.
discuss and then he
Absolutely.
should explain. This is the only thing you will get. You will
Right.
not get more than that. So kindly settle it here itself.
But I think India is still far behind in taking those aggressive steps and pushing parties.
And in our
To the edge.
present setup, that is not possible as we said.
Why do you suggest that, sir? Why
sir.
do you think no hard and
Legally, how
fast?
could you speak to the parties as a judge, presiding officer? You can only say, as a particular level, I am referring to you.
A trial judge, sir, in my respectful submission, of course, no law as such either prohibits this or tells you to pronounce the judgment. It is just the innovative thought of the judge concerned. He says that, look here, I am leaving you even free now after litigated in my court. A chance to come back to your own terms.
Then
No law, I think, sir,
Yes.
prohibits that.
No law.
And if the parties, even at that level, can arrive at a better settlement, the kudos to the judge who sacrifices all his
Time and
labor
effort. Yes.
and says, all right,
then you will be branded as prejudice.
Prejudice.
So there is so much of role for legal professionals.
Yeah,
So
from
It's
the
all
ground
finally-
level.
have to
From
get
the-
trained.
it's finally on the lap of
Finally
the
on
law.
us,
Finally on the
because
law.
we have to
Simply
push.
say this is the position, you better go to the mediator.
For mediator.
So I am referring to that.
Hmm.
You spend your
Which
time.
we do in our
Right.
routine.
Yes.
What
We have done it. Many
And
cases
it's
we
a
have
good
done.
idea. I think probably Vijay was saying it that it should be, or and so, my brother was also telling that it should be the like preliminary stage. You have to go for mediation. It can be made compulsory. Nothing bad about it.
Now let
No,
us.
provisions like Commercial Codes Act 2015,
They already
they
have.
mandate section 12 capital A. They say before coming to court, you will have to go to mediation.
Correct.
And if only it fails, you come here.
Correct.
And only for urgent interim leave, directly coming is
Directly
permitted.
coming back.
This is what commercial courts have. Even in corporate matters,
Corporate
business
code,
disputes,
absolutely.
they have provided.
Absolutely. Now these
So
days.
now the days are coming, I think, where the
Yeah.
mandatory and the corporate agreements, now I am seeing so many agreements. There are two clauses. Arbitration clause, above that there is an amicable
Mediation.
settlement clause.
Yes, sir. Amicable settlement.
So you will have to try first an amicable settlement. If not that, then go for arbitration. If not that, then come to the court.
Then come to the court.
So the
Right.
law is now evolving.
Most of the agreement, arbitration clause will be the last but one.
Last
Just
but one.
before that, there is an
Amicable
clause for
settlement.
amicable
That clause is always
conciliation
there.
or amicable
But that is
settlement.
not followed in most of
No,
the
no, but it's gaining
No,
importance. This
really.
multi-tier arbitration and dispute resolution is gaining a lot of traction now.
Right. So that's about the mediation. Now, India, compared to the other countries, like for example, we pick up Singapore, which is another Asian country. Singapore has advanced so much in mediation, and India is now trying to catch up. And there is a Singapore Convention as well on mediation. India has signed the convention but has not ratified it. Now, I wonder what those reasons are, which is still stopping them from
I
ratifying
think
that.
this new law which is now on the table. Maybe
In
a
India.
reason because they will finalize this law first and then ratify it also.
You
Because they for international perspective, they have to toe the line or fall in line like that. And unless that happens, what to do with business disputes,
correct,
which runs into such a huge stakes.
right?
And we have this, I have some dabblings in international taxation. MAP procedure, mutually agreed procedures. They have this settlement process, mediation process, even in the taxation matters.
Oh.
So the law is developing worldwide now. That litigation system, as far as possible, please avoid. Have your selected trained judges, mediators, trainers, arbitrators, whatever you call them. There are centers now
Provisions
where
are
this
there.
all this skill knowledge is available.
There
in
they have
the
already created, all those things are
So
there.
mediation is the need of
Implementation.
that.
Mediation is the need. of the-
Finally, you see, is a cycle.
Right.
You have to come back, having experienced all the pitfalls and back things of
Correct.
litigation. Time has come to now see the sense of mediation.
Correct. And who? Now let us talk about this bill. Now that you have you stirred the boat on that front, let us talk about the recent mediation bill, which is pending in the parliament and has still not been passed.
It's a good bill to first because it's coming on the table at the instance of the Honorable Supreme Court. In 2019,
Right,
Justice
right.
Sikri, in a judgment, Krishna Swami's case, said that the parliament has to take up this kind of, because a separate dedicated law for mediation should come. Section 89 was not found sufficient. So this draft of bill has according to them after the standing committees have discussed that and all that.
Right.
But there are still shortcomings in that, like making mandatory before coming to courts, settling of this fees structure, training or provisions are made. But implementation in our country has been a
Has been a challenge. Has always been.
So
That is
2019 that judgment came, 22 mid we have crossed. Except the bill we don't have anything.
Right.
By this time the infrastructure with the institutionalized mediations should have been at least in place
Yes.
on the legal framework. Then it will take 2-3 years for people to fill up those infrastructures and be ready to really serve the cause.
In your experience, sirs, how far do you think we are still?
My estimation, I am optimistic. So 10 years from now, probably, we will have a matured mediation system in place in our country.
We have to, sir, we have to, if we have to move forward, we have to improve upon such mediation.
Many
Can
things.
mediation be cost effective, time effective? So many benefits are out there, but still our litigious mind trying to push and push and push
They were pointed out,
stops up
mediation
from
mindset.
the litigious mind. So what I understand is the core of what our country and our people need to understand is to change the mindset.
Minds. That
See,
is
it
finally-
is not, does not stop with one party A or B alone. A has got some kind of people behind him, B also got few people behind him. They only do it.
Right. So it's the right education which needs to be given out to the people out there in order to understand the benefits of
Each
mediation.
one has got some vested interest, therefore they want to blow their interest. That's
Well, I think it would be go a long way if you could actually educate the coming batches of lawyers and make mediation as a mandatory subject in their curriculum and syllabus.
The bar is very important.
Then I think the bar could play a very
Now
important
some
role in.
universities have introduced mediation as a subject in their law
That's
profession.
interesting.
But it should be widespread, more
Widespread.
So moral ethics we have to all have to
Yes,
follow.
yes.
Okay, no, because while it
And give them proper incentive on the fees scale also. Finally,
Absolutely.
somebody will
Unless
give us
that
the
comes
bread and butter for your so-called good consents. So you should take care of the economics
yeah,
also.
except very
And
poor persons
if the lawyers feel,
It Actually, so now there is amicus curiae is appointed for each case by the court, and the government, they also being paid from the government funds. How much success it is there? Yes, we see.
Correct.
We should not allow it to suffer like that.
Yes.
It will not,
Quality in training
is
matters.
more important.
Quality requires more.
See, amicus curiae is appointed in each case. Wherever the party says, I am not in a position to engage an advocate, the court immediately appoints an amicus curiae.
But sir, as judge, you must have also seen what is the quality of the panel lawyers who are there. They are young boys and girls who are desperate to have some case. But then they are only beginners.
That legal aid.
They
legal aid,
we
na?
should be good, matured lawyers, 10-15 years standing, who can really assist the
Yes.
court in
Absolutely.
That's, I think we must then incentivize the older lawyers to take an active part in.
So sir is rightly taking, because if you see the drafting of what legal aid persons have
understood.
been done, just 1 year, 2 years of experience.
pitiable,
And then-
madam.
And if once somebody was arguing, and then I asked,
You know, we have
who is
to-
that? Why he is arguing like that? They said legal aid ka hai. So
Let
let's
the legislation be brought in, then we have to try that step by step, we have to advance. Amendments, this and that will happen, then automatically amendment.
Now, when we talk about the legislation,
This civil procedure code, how many thousands of times it has been amended? It was only few sections, now what are
Now
the
it is
sections?
there's such a
Where
big
it itself, how much it comes.
yes.
Every time there is something, commission, this and that, amendment is introduced.
I think the reason it comes out is because of we lawyers who always try to pull out the loopholes in everything. The more the loopholes, the more the sections it has to come to protect.
That's how the mindset is.
Okay, we are seeking for always the clauses. What is the clause which will help me?
Absolutely. Now, talking about the legislation, one of the key features in the recent mediation bill which has been promoted is pre-litigation or compulsory mediation. So, what it suggested, I think it was also there as we were talking earlier about the Commercial Codes Act, Section 12A, where it makes it a pre-step in order to go to mediation and then proceed to litigation. However, it is not kept to be mandatory. But now I think it is taken care in the mediation bill which is pending, where they say mandatory mediation. What are your thoughts on that? I mean, because keeping the litigious mind of people, one would just go for the sake of going and just say, no, I'm not a party to it, and walk out. So how do you think this compulsory mediation is going to help?
It's only an attempt to mediate between the parties.
So it's an attempt to change the mind, but not exactly
Promoting the idea.
Promoting the idea. But
And then we can just hope for success, because even if you look at the matrimonial acts, before a divorce is granted, there is actually a process for conciliation.
Yes, even in that
And I'm quite
case,
certain it's 99.9% that conciliation has been a failure.
Yes.
It doesn't happen. We can just hope and pray that this mediation, pre-litigation mediation, doesn't go the same way.
But the success of this will also depend upon how the person sitting in that room
how they perceive.
deals with that.
Yes.
The expertise of the mediator is
So
also.
putting that as a mere compulsory section, saying the compulsory mediation is still maybe of no consequence until and unless we have people to
Because we know in
distribute
other
that.
laws we make always a proviso. So they say, if you need interim relief, you can directly come to court. Everybody needs an interim relief.
Absolutely.
So why close that door? Why don't you close that door?
As brother said, in almost all the cases,
10% success rate, you said 90% of them failed. Do you have any success stories that you can share of?
Not much.
Maybe on a very
I'll share
you
one
do have
success
some stories.
story.
Please, let us hear from you,
As
sir.
a judge, when I was sitting judge, somebody known to us in a family, in a matrimonial dispute, came to me. Sir, you are a High Court judge. Will you be able to get our cases expedited if we file it as a great financial dispute is going on? Families are fighting, and the wife is demanding so huge alimony and this and that. How to do it? Then I said, if you want to rely upon me, the first advice is don't enter the court. The second advice is that if the wife is demanding, say for example, 2 crores, give her 2.5 crores and settle your mindset that there was some dacoit in your place, your 2.5 crores are lost. Because if you go to court, you will not only finally pay 2.50 crores, 50 lakhs to the lawyers. So it will be 3 crores.
Plus the time.
Plus the time. So matrimonial disputes, I said earlier, it's a mirage. Looking to the levels of these appeals and all this. So my advice as a family friend, as a sitting judge, as a lawyer, to them was pre-litigation. Don't enter the court.
Enter the court.
So that should be the firmness of advice, that should be the mindset of the advice, that should end with that family settled.
Oh.
And I will tell you a story. Motilal Nehru in 1941, Birla people went to him for advice on a dispute. He said, I'll give you advice. 1 lakh rupees is fees 1940. He took 1 lakh rupees. Come after a week. After a week, the parties went to him. The envelope was given to them. They opened and said, in this case, in my opinion, do not file a suit, try for mediation. Close game. After settlement, they came back, sir, 1 lakh more. Your advice was so valuable, we tried and we succeeded. So this is the kind of mindset which is required, this is the kind of advice which a sane person should give. And that is where we require all this.
One more aspect of the matter is, many people say in USA or England or somewhere, nobody is prepared to depose falsehood.
Here it is a practice.
Yes, here it is a.
Here, left and right, we are prepared to quote the falsehood
Yes.
and affidavit also, as well as everything.
Everything,
Then
absolutely.
what else they could do? That mindset will be there from the beginning, childhood itself, it should be developed. Don't lie. Don't say falsehood.
So it all starts from the grassroots, our education.
Yes, that is more important.
Maybe we should have just stuck with our laws rather than have the white
In
man
America,
laws
if you
postpone
go
us.
to litigants come to the court, all those things. No, I will not say falsehood. Then the advocate
Yes.
says you have to depose, then only
You
your
have to
case is
depose,
sustainable. They said, no, I don't mind. Let me lose the case. I will not speak
Tell the
falsehood.
false.
Correct.
So, everybody should be taught from the beginning, childhood, don't lie. Don't speak falsehood.
Civic, basic moral.
Basic
Or
morals.
Basic structure.
Right.
if you are wedded to that, then there will be not much of this litigation. All this started from British rule onwards.
British rule onwards, right. So we were saying earlier to that we were in the barter system, where
Yeah.
there was no exchange of monetary sums. Because you give this, you take this.
Goods versus goods.
Goods versus goods. So therefore it kept it made life easier at that
This is
point of
the-
time.
Values of the society.
Marriages.
Right.
That's where we suffer.
Right. Tell us in your experience, sir.
Ask your litigant who comes to you, or even for mediation, will you speak truth? Will you depose an affidavit containing only truth?
People sign that also.
It is too much to expect.
Whatever I say is the truth and nothing else. I think they sign it on that.
We write those words more as poems rather than.
And what makes matters worse is, we, as lawyers, we'll say sign before me also.
The mindset is that. That is the reason for all our litigation which we are facing.
Talking about the mindset, let's hear it from the advocates. How often do you feel that this case is fit for mediation, and how often do you get such cases, and do you direct them to mediation?
Over the past couple of years, I've necessarily felt, disputes, majority of them are settleable and must be settled. But of course, I'm not a Motilal Nehru who can give the send the thing and expect a repeat. So I go
Motilal Nehru was Motilal. He had so much of litigation also.
So I gently tell them, yes, fix a time frame. If it settles within the time frame, which is good, explore the possibility, because if you do that, you can put a full stop to this now. Otherwise, what happens is you're looking at 20 years, an appeal and appeal and appeal, and maybe your children may see the degree. I also tell them that in a litigation matter, there is actually no winner. You may have a decree, but you're really not a winner.
Right.
Keep re-emphasizing that as mediated settlement is any day better than litigated decree.
Okay, sir. Well, yes, I think we've done that. I would just finish this entire talk with just one
Don't
question
finish
to each
it,
one.
complete that.
And continue that even if we are not there.
Absolutely, we are definitely going to do that, sir. But before we all disperse, one last request to each one of you, and would like each one of you to share a message, what they would like to tell the people in order to promote mediation and in order where we could say something which could change the mindset of the people.
If the person want to go by the advice of mediator, he must have in his mind his good health, his good mind, his family's good reputation, all those things in his mind. Then only he can avoid the litigation. Litigation is costly by all standards. Litigation will not end, will not see life after life also, many cases. On the other hand, if you go for mediation, if you arrive at a settlement, then that is the best thing for the both sides.
Right, sir. Let's hear from you, sir.
In short brief, I would say, mediation is the idea whose time has now come. And we all in legal fraternity, whether we are lawyer, judge or whatever, we should change our mindset and try to change the mindset of people at large. That this is a very effective way which will solve your problem at much lesser cost in the form of money or time. So let us educate ourselves, let us dedicate ourselves, and let us evolve. I would say.
One last point, just
Yes.
is the responsibility of the lawyers also to tell the public that very often disputes arise not because of what is said or what is done, but rather how it is said and how it's done. And people generally tend to take positions because of how it's done. It's the mediator's responsibility, and which is a very easy first step to educate people, to tell them that the positions you're taking is not materially on what was said,
Correct.
but rather how it was
How
said.
it is
So the mediation is the need of the hour, and we should have trained mediators who can help people to come to discussion table. And what you have written again, start talking, start discussing, start educating, and let's sort it out.
I think you did not read. Did you get a chance to read what's written in the front?
No, it was
Mahatma
written there.
Gandhi's quote right in the front.
Yes.
Oh,
When you go on
He went for a mediation in this beginning of his career.
Yes.
And he said, I did not lose anything. I earned a reputation.
Reputation. Absolutely.
He lost everything in litigation.
Well, thank you very much, sir, for each one of you for joining us.